Good afternoon, good evening, good morning, and welcome to Leaving Hillsong. My name is Tanya Levin, and I've been away for a while due to some work commitments that were just overloading. And while I was away from my keyboard, the transcripts from Brian Houston's Judgment Day arrived. And so I thought, what better way to make a little bit of a mini comeback, so we won't go like that long, than to read to all of you what the judge said on the day. The day in question is the 17th of August 2023, when the verdict was handed down in the case of the Crown versus Brian Charles Houston in the matter of concealing a serious indictable offence. This is the soonest we've been able to get a hold of the transcript directly from the court. It's a small courtroom. There are only a few people present, and so most people don't know exactly why the verdict that was delivered was decided in the way that it was. So without further ado, this is being read directly, verbatim, as it were. So, don't shoot the messenger. It'll be broken down into two parts, and part two will be with you as soon as possible. Probably tomorrow. Huge thanks and shout out to Jake Elliot from the Framework, who assisted me at very short notice in making this happen. This is Judgment Day. The following is from the transcripts of the trial of Brian Charles Houston. This is the judgment handed down by Magistrate Gareth Christophe on 17th of August 2023. My name is Tanya Levin. This is an episode of Leaving Hillsong. We will read the transcripts directly. In the local court, Downing Centre, Magistrate Christophe, 17 August 2023. Case number 2021/00224306, Brian Charles Houston. Closed court. Offence: conceal serious indictable offence of another person. Sergeant Dodds for the informant, Mr. Bolton for the accused. His Honour. The accused, Brian Houston, is charged with a single offence of concealing a serious indictable offence under Section 316 of the Crimes Act, New South Wales. The offence is said to have occurred between 15 September 1999 and 9 November 2004. The accused pleaded not guilty to that charge, and the matter proceeded as a defended hearing before me. This is my judgment. For the Crown to succeed, it must prove each of the elements of the offence before the court and prove them beyond a reasonable doubt. The accused bears no onus of proof and enjoys the presumption of innocence. The elements the Crown must prove are as follows. A person committed a serious indictable offence, that is an offence punishment by imprisonment for 5 years or more. The accused knew or believed that a person had committed a serious indictable offence. The accused knew or believed that he had information which might give material assistance in securing the apprehension of that person and or in the prosecution or conviction of that person for the offence, and the accused failed, without a reasonable excuse, to bring that information to the attention of a member of the police force or other appropriate authority. In this case, the first three elements are not in dispute. In relation to the first element, it is not in dispute that a man named Frank Houston, the father of the accused, committed a serious indictable offence. An agreed statement of facts, Exhibit 2, was tendered in the proceedings, which establishes that between January 1969 and December 1974, Frank Houston indecently assaulted Brett Sengstock and did so on more than one occasion, and at a time when Brett Sengstock was a child. The details of those indecent assaults are set out in Exhibit 2. In relation to the second element, it is not in dispute that the accused came to know or believe that the serious indictable offence had been committed. In fact, his father, Frank Houston, admitted it to him in 1999. In relation to the third element, it is not in dispute that the accused knew or believed that he had information that would be of material assistance to the police. He knew the name of the victim, the perpetrator, details of what had occurred, and where it had occurred. He knew that Frank Houston had admitted to the crime. In relation to the fourth and final element, while there is no dispute that the accused failed to bring the information he had to the attention of the police, it is very much in dispute as to whether he had a reasonable excuse for not doing so. The accused claims that he did have a reasonable excuse, namely that he knew or believed that the victim of the serious indictable offence, Brett Sengstock, did not want the matter reported to police. He wanted to respect the victim's wishes, is the accused's position. The Crown case is that the accused had no such reasonable excuse. The Crown contends that the accused did not know or believe that Mr. Sengstock did not want the matter reported to the police. Alternatively, that if he did have such a knowledge or belief, then that was not the reason why he failed to report the matter to the police. He had all times acted, the Crown argues, only with the intention of protecting the reputation of this church, and therefore his excuse, it is argued, was not reasonable. Put simply, the Crown case is that this was a cover-up. Section 316 of the New South Wales Crimes Act did not, during the period of alleged offending, define what a reasonable excuse is. However, there is no dispute between the parties that a reasonable excuse would be available to someone who sought to respect the wishes of the victim by not reporting the matter to police. In 2018 and 2020, amendments were made to the New South Wales Crimes Act to provide a non-exhaustive list of what can constitute a reasonable excuse for an offence of concealing a serious indictable offence where that offence is a sexual offence or child sexual abuse offence. It has now been legislated that a person has a reasonable excuse for failing to bring such information to the attention of the police if, at the time the information was obtained, the alleged victim was an adult, and if the person believes on reasonable grounds that the alleged victim does not wish the information to be reported to the police or other appropriate authority. It is argued by the defence, and not in dispute by the Crown, that the amendments did not introduce a defence that did not previously exist. It simply codified what would have always amounted to a reasonable excuse. I agree with that submission. There are sound policy reasons why respecting the wishes of a victim of sexual abuse not to go to the police is not a criminal act. Firstly, victims of sexual abuse ought to feel safe to confide in others without being concerned that they are exposing those others to prosecution for a criminal offence. Secondly, given the highly personal and often devastating impact that sexual abuse, and in particular child sexual abuse, has upon the victims of those crimes, the decision to report or not report such matters to the police ought to rest with the victim. Potential for significant psychological harm exists if victims of sexual abuse or child sexual abuse do not have agency and autonomy over when and to whom they would make a disclosure. It is important to keep in mind the onus and standard of proof as it relates to the fourth element. It falls to the Crown to prove that the accused did not have a reasonable excuse and to prove that beyond a reasonable doubt. The accused does not need to prove that he had one. This is an important distinction. If it remains a possibility that the accused did have a reasonable excuse, then the Crown case must fail.
Background. At the time of these events, there existed an organisation known as the Assemblies of God, or AOG, which later, in 2007, became the Australian Christian Churches. This was an association of Christian churches within the Pentecostal tradition. The AOG oversaw about 1,000 member churches around Australia. Each individual church was, to a large extent, self-governing. However, the AOG had power over such things as the accreditation of pastors and the management and investigation of complaints made against pastors. The AOG had 3 tiers of governance: district executive committees, state executive committees, and a national executive committee, or NEC. The NEC was the AOG's peak body. The AOG also had a presence in New Zealand. Frank Houston was born in 1922. died on 8 November 2004, aged 82. He was born in New Zealand. As a young man, he became a pastor and ministered to a church which was affiliated with the New Zealand AOG. He became a successful and well-known pastor in New Zealand, as well as in many parts of Australia, where he would travel frequently to preach. He moved to Sydney in around 1977 and set up his own church in the eastern suburbs called the Sydney Christian Life Centre, or Sydney CLC. That church soon became a member of the Australian AOG. Frank Houston became an accredited pastor within that movement and was soon a prominent and revered figure within the Assemblies of God in Australia. Brian Houston is the son of Frank Houston and is the accused in these proceedings. He was born in New Zealand in 1954 and grew up wanting to be like his father. The accused began preaching at the Sydney CLC, but eventually in 1983 he and his wife established their own church in the Hills district called the Hills Christian Life Centre, or Hills CLC. Their church was also a member of the Australian AOG, and the accused was an accredited pastor within that body. The Hills CLC grew very rapidly, as did the reputation of the accused. In around May 1999, when Frank Houston was about 78 years old and considering retirement, he handed over control of the Sydney CLC to the accused. The accused then became the senior pastor of both churches. The accused became the president of the Assemblies of God in Australia in 1997. Held that position until about 2009. The Hills CLC changed its name to Hillsong in about 2001 and became a popular church in Australia and in other parts of the world.
Brett Sengstock and sexual abuse. Brett Sengstock was born on 4th of January 1962. He grew up in Coogee. His parents were devout Pentecostal Christians and attended a church that was affiliated with the Australian AOG. They were friends with Frank Houston. In the late 60s and early 70s, when Frank was visiting Sydney to preach, he would occasionally stay overnight at the Sengstock household in Coogee. On occasions, Frank would be in company with his own family members, including his son, the accused. One evening in January 1970, during one of these overnight visits to the Sengstock house, Frank Houston sexually abused Brett Sengstock. At the time, Brett Sengstock was a boy of only 7 or 8 years old. As I have said, this is not in dispute and is contained in the agreed statement of facts in Exhibit 2. The accused was not aware at the time that this offence had taken place. Brett Sengstock did not tell anyone what happened to him at the time or for many years. His family remained steeped in the culture of the church. He was a child and he felt a deep sense of shame and embarrassment, as, unfortunately, many victims of child sexual assault do. Diary entries made by Miss Hardingham established that she was told of the abuse by Mr. Sengstock on 31st of May 1994, when Mr. Sengstock would have been aged 32. The diary entries suggest, at least from Ms. Sengstock's point of view, that she knew nothing about it before then. Barbara Taylor and then Kevin Mudford learn of what happened. Barbara Taylor was a pastor in the Emmanuel Christian Family Church in Plumpton and had been so since 1977. That church was a member of the AOG in Australia. Ms. Taylor knew Rose Hardingham and Brett Sengstock both as members of her church, and because Ms. Taylor was Brett Sengstock's aunt by marriage. At some stage in the late 1990s, Ms. Hardingham told Ms. Taylor that her son Brett Sengstock had been sexually abused by Frank Houston. Ms. Taylor was told this in the strictest confidence and agreed at the time never to tell another soul. Ms. Hardingham explained that the need for secrecy was because her son did not want anyone to know about it. On the 3rd of November 1998, Ms. Hardingham confided in an evangelist named Kevin Mudford. She told him of her son's abuse at the hands of Frank Houston. Kevin Mudford was a travelling evangelist who, at the time, was visiting the Emmanuel Church. Following this, Kevin Mudford spoke to Ms. Taylor about the matter. The two decided to escalate the issue and met with a senior pastor named John McMartin for some guidance on what to do. Pastor McMartin was a member of the New South Wales State Executive Committee, or SEC, of the AOG, and ran his own church in Liverpool that was a member of the AOG. That meeting occurred on the 4th of November 1998. The issue was then raised by Ms. Taylor and Mr. Mudford with Mr. McMartin in a general way, without mentioning names but identifying the perpetrator as a senior minister. At that time, Mr. McMartin provided little advice on what they ought to do. He suggested that they be led by the Lord. At a more practical level, he also suggested that they raise the issue with Brian Houston, who was then the president of the AOG, as I've said. However, at least at that stage, neither Mr. Mudford or Ms. Taylor felt they could do this because of Brian Houston's revered status within the church. The visit to Brett Sengstock's house on the 5th of November 1998. On or about the 5th of November 1998, Barbara Taylor and Kevin Mudford attended the home of Mr. Sengstock, uninvited and out of the blue. At the time, Mr. Sengstock was living in Collyton and was aged 36. Ms. Taylor and Mr. Mudford confronted Mr. Sengstock about the topic of his abuse as a child perpetrated by Frank Houston. Memories differ significantly as to what exactly transpired at this meeting. Mr. Sengstock's recollection was that Mr. Mudford was verbally aggressive and abusive towards him. It is likely that the recollection is inaccurate, because there can be no doubt on all of the evidence that Kevin Mudford was animated by a sense of outrage at what Frank Houston had done and was seeking for justice to be done. Brett Sengstock also recalled that Ms. Taylor was insistent that the matter ought not to be made public, but rather ought to be dealt with by the church. Mr. Sengstock felt dismayed, shocked, and blindsided by this confrontation. Knowing that it could only have been his mother who informed Ms. Taylor and Mr. Mudford about what had happened to him as a child, Mr. Sengstock felt as if she had betrayed his trust. He had never told his mother that she could tell anybody else about the topic, and he never thought that she would. Events following. In the days that followed, Ms. Taylor spoke again with Mr. Sengstock and encouraged him to meet with Frank Houston. Ms. Taylor, being a devoutly religious person, sincerely believed that Frank ought to repent directly to his victim, and that this was an indispensable part of dealing with the issue, or as Ms. Taylor would put it, an opportunity for healing and restoration. She also informed Mr. Sengstock that she would stand by him if he made a formal complaint to the church, but not if he made a complaint to what she referred to as the secular courts. On 26th of February 1999, Ms. Taylor wrote a letter to Frank Houston encouraging him to meet with Brett Sengstock face-to-face at her church. Her efforts were continued through April 1999, but no such meeting took place. In Taylor's view, Frank Houston was, at that time, trying to avoid the issue. In May 1999, Frank Houston telephoned Brett Sengstock. He admitted to the sexual abuse and issued a tearful apology. Mr. Sengstock informed Ms. Taylor of this. Mr. Sengstock and Ms. Taylor remained sceptical as to whether the apology was genuine. On the 19th of May 1999, Ms. Taylor wrote to Mr. McMartin, updating him on everything that had transpired since their first meeting, including that the perpetrator had confessed. In September 1999, Ms. Taylor met in person with Mr. McMartin, discussed the matter further. By now, Ms. Taylor had informed Mr. McMartin that the perpetrator was Frank Houston and that the matter involved an allegation of serious misconduct against a minor. Ms. Taylor likely conveyed to Mr. McMartin her belief that the victim did not want to make a written complaint about the matter. Mr. McMartin stressed that while the church had an internal structure to deal with such issues, without a written complaint, not much could be done. At around this time, Mr. McMartin had a telephone call with Wayne Alcorn, a pastor on the National Executive Committee. Mr. McMartin informed Mr. Alcorn of what he had been told, including the substance of the allegation, and that the victim did not want to make a formal complaint about it. Mr. Alcorn encouraged Mr. McMartin to speak directly to the accused about it. The letter from Ms. Taylor dated 16 September 1999. Ms. Taylor then wrote to Mr. Sengstock on 16th of December 1999. She informed him that she had spoken to Pastor John McMartin. She informed him that the Assemblies of God had a structure to deal with such matters, if they had a written accusation with time and place. She also wrote that in her view, the secular courts is not the way to go, but to the church, where I believe you will receive a fair hearing. She reassured Mr. Sengstock that she believed him and would stand with him. In short, the letter was urging two things upon Mr. Sengstock. Firstly, to come forward and to make a formal written complaint. Secondly, to do so through the structure of the church, rather than going to the police. Brett Sengstock did not take up Ms. Taylor's suggestion about making a formal complaint either to the church or the police. The accused learns of the allegations. In about October or November 1999, Kevin Mudford rang George Agajanian, the then business manager of the Hills Christian Life Centre. Mr. Mudford informed Mr. Agajanian of the allegations of sexual abuse that had been made against Frank Houston. Mr. Agajanian advised Mr. Mudford that he would look into the matter and investigate. As it happened, Mr. Agajanian had a pre-arranged weekly management meeting with the accused that very afternoon. Mr. Agajanian told the accused what Mr. Mudford had told him earlier that day. Mr. Agajanian recalled that the accused was shocked to hear the news. This was the first time the accused had heard of the matter. The accused asked Mr. Agajanian who else knew about it, and Mr. Agajanian listed those who he believed knew. This included the name of John McMartin. The accused informed Mr. Agajanian that he would speak to his father, Frank Houston, about the matter. Soon after this, the accused and Mr. McMartin spoke by telephone and discussed the issue. Recollections differ about how this call came about. The accused's evidence was that he rang Mr. McMartin to ask him about what he knew and why he had not told the accuser about it earlier. Mr. McMartin's evidence was that it was he who rang the accused and informed the accused about the matter, and the accused appeared to be hearing it for the first time. I prefer the accused's evidence on this point, as it is more consistent with the evidence of Mr. Agajanian, namely that it was Mr. Agajanian who firstly told the accused about the matter and saw the accused's shocked reaction upon hearing it. As well, Mr. McMartin's evidence on other matters, including his assertion that he never received any correspondence from Ms. Taylor, was implausible and at times incoherent. Ultimately, however, the distinction matters little. The two men spoke, and the accused told Mr. McMartin of his intention to raise the matter with the National Executive Committee. Events following. On the 25th of November 1999, Ms. Taylor had a phone conversation with Brett Sengstock. She made a note of that conversation. Among other things, she noted that Brett Sengstock was weighing up whether to go to the secular courts for compensation. She also noted that Brett feels he has lost power because of this exposure through his mother. He feels that he has lost power because of this. Brett Sengstock, she noted, also remained highly sceptical that there was any benefit in taking the matter up formally with the church. On the 28th of November 1999, Ms. Taylor met personally with John McMartin and the accused, Brian Houston. She again made notes of that meeting. Her notes record that Brian Houston said that he and his family were in shock and that his father would be stood down from preaching. Ms. Taylor also told the accused at this meeting that she believed there was a possibility that Brett Sengstock would go to court. According to the note, the accused said that he had spoken to a barrister who had told him that if the matter were to go to court, his father would surely be incarcerated. The note also records that the accused said that he had spoken to his father and that his father had confessed. Ms. Taylor rang Brett Sengstock the following day and informed him of what had transpired at the meeting the day before. She advised Mr. Sengstock to contact Brian Houston for ministry. Ms. Taylor then wrote to Brian Houston on the same day and encouraged him to contact Brett Sengstock. At that point in time, Ms. Taylor had hoped that the matter would now be taken up by the church hierarchy, be dealt with appropriately, and that her involvement could cease.
The Sydney Airport meeting of 22 December 1999. A day or two before 22 December 1999, the accused rang Keith Ainge. Mr. Ainge, at that time, was the National Secretary of the Assemblies of God. The accused asked Mr. Ainge to arrange an urgent special meeting of the National Executive Committee. The accused did not tell Mr. Ainge what the meeting was to be about, only that it was urgent. Mr. Ainge contacted all of the members of the National Executive Committee. The meeting took place at the Qantas Club at Sydney Airport on 22 December 1999. This venue was chosen because the various members of the National Executive Committee resided all over Australia. The meeting was initially chaired by the accused, a role he would normally assume as president. However, after explaining what the meeting was about, the chairmanship of the meeting was handed over to the vice president, John Lewis. This occurred at the instigation of the accused. The accused provided information to the meeting on the topic at hand, but played no role in the decisions made at that meeting. The minutes of this meeting, which were kept by Mr. Ainge, became an exhibit in the proceedings. The minutes reflect that the accused informed the meeting that an allegation had been made against his father, Frank Houston, of a single act of sexual abuse more than 30 years ago. Further, that the complainant did not wish to be identified and did not wish to make a formal statement, but that Frank Houston had confessed to the act. While the minutes do not directly reflect this fact, Keith Ainge gave evidence in this hearing that the accused made it clear that the complainant had been a minor at the time of the sexual abuse. The minutes also note that the accused had already suspended the credentials of Frank Houston. The meeting agreed that Frank Houston's credentials would now be withdrawn and that he would be invited to enter an AGO restoration program and placed under the supervision of Ian Woods. Further, that Frank Houston would refrain from a public ministry for 12 months. Ian Woods was, at the time, the state superintendent in New South Wales and a senior minister at the church which Frank Houston then attended. The minutes noted that the meeting agreed that in the interests of the complainant, there would be no notification of the wider church of this disciplinary action. The minutes also noted that it was agreed that the accused would meet with the complainant and explain the process of discipline and restoration that had been followed. It was agreed that the complainant be assured that his identity had not been disclosed and that his desire for anonymity would be honoured. The minutes do not mention the name Brett Senstock. The minutes also noted that legal advice had been obtained as to, quote, our obligations in this matter, close quote. While there is no record of this in the minutes, Keith Ainge gave evidence about what he could recall about that matter. The legal advice, he said, was to the effect that because the victim was now an adult, and because the victim could make his own report to police, but did not wish to do so, then the church had no obligation to make its own report. Mr. Ainge could not recall who it was at the meeting that had conveyed that legal advice. The minutes also noted that any inquiries in relation to the matter were to be directed to John Lewis. According to Mr. Ainge, the National Executive Committee deliberately charted a course at this meeting whereby the accused would not be the primary person responsible for dealing with future issues arising from the decision-making that would follow in dealing with this matter. There was no mention at this meeting of any payment of money that had been made to Brett Senstock, a topic that I shall come to shortly. The evidence is unclear as to whether Mr. Senstock had been paid any money at this stage. However, Mr. Ainge gave evidence that he had a recollection of being told by the accused at some stage after this meeting that Frank Houston had met with Mr. Senstock and discussed money. According to Mr. Ainge, the accused also said something to him at that time along the lines of, quote, I've had nothing to do with it, close quote. That's to say the money, quote, but I hope it doesn't appear as if it's some sort of hush money, close quote. Mr. Ainge said this conversation with the accused likely happened in early 2000. The payment of money to Brett Sandstock. At or about this time, Mr. Sandstock began receiving phone calls from Frank Houston. According to Mr. Sandstock, in these calls, Frank Houston wanted to meet him and talk about compensation. He would also say words to the effect, quote, "We do not need to have this all exposed, and no one's going to believe you anyway," close quote. On one occasion, Mr. Brett Sandstock agreed to meet Frank Houston at Redfern Station, but when he attended the location, Mr. Sandstock left upon seeing Frank Houston's car. Eventually, the two did meet at a McDonald's in Thornleigh. It is unclear when this occurred, but it is likely that it occurred somewhere between mid-1999 and May 2000. Frank Houston was in the company of another man at this meeting. His name was Nabi Saleh, but whom Brett Sandstock did not know. Nabi Saleh was a board member of the Hills CLC and a close friend of Frank Houston at that time. According to Brett Sandstock, a scrunched-up napkin was produced at the McDonald's meeting, and Frank Houston said words to the effect of, "Sign here, it will all be over with, you'll get your money, we'll just keep this between ourselves. If you have any problems with this to get the money, contact Brian Houston." Brett Sandstock believed that by signing the napkin he would be receiving $10,000, an amount that was mentioned at the meeting. Some weeks later, Mr. Sandstock had not received any money. As he had been urged to do by Frank Houston, Mr. Sandstock said that he phoned Brian Houston, that is, the accused. The contact between Mr. Sandstock and the accused and what was said by each is a topic very much in dispute in the hearing. Mr. Sandstock gave evidence that when he phoned the accused to inquire about the money, the accused was angry and made a highly offensive remark, which was, quote, "You know this is all your fault, you tempted my father," close quote. The phone call ended with the accused saying, quote, "You'll get your money," close quote, and then slamming the phone down, according to Mr. Sandstock. There was no discussion in the phone call on Mr. Sandstock's version of other issues, such as church counselling or the possibility of a church or police investigation. According to Mr. Sandstock, this was the only conversation that he and the accused ever had about the issue. Mr. Sandstock denied ever telling the accused that he did not want to go to police. According to Mr. Sandstock, several weeks later, a check turned up for $10,000, which he deposited into his bank account. The evidence as to when he received the check is unclear as to when this occurred. It is highly probable that he received it sometime before 22 May 2000, but how long before is not known.
Ms. Taylor follows up with the accused about what was happening. By June 2000, Ms. Taylor had still not been told of what, if anything, had been done by the church in relation to the matter. On the 26th of June 2000, she wrote to Brian Houston, the accused, expressing her concern and disappointment that nothing had, at least to her knowledge, been done. She wrote, "I'm appealing for a definite attempt to be made towards restoration of both parties." On the 19th of July 2000, Brian Houston phoned Ms. Taylor and spoke to her regarding her letter of 26th June. Ms. Taylor made a note of the conversation. According to the note, Brian Houston informed Ms. Taylor, among other things, that the National Executive Committee had met to consider the matter, that a meeting had taken place between Brett Sandstock and Frank Houston, with a member of the Christian Life Centre present, likely to have been Nabi Saleh, and that the Executive Committee had spoken to Kevin Mudford. Brian Houston also spoke of being very hurt by Ms. Taylor's letter and said that his father had been abused as a child, was depressed, in poor health, and had a failing memory.